Good day, class, and welcome to Title 2 of Corporation Law. So today we shall be discussing about incorporation and organization of private corporations. Let's begin. So Title 2 talks about the steps in incorporation. So incorporation means the act of creating, of forming a corporation. So we shall be discussing this under the revised corporation code of the Philippines. All right. So our corporation code has been revised. We now have the revised corporation code. So step one is reservation of the corporate name. Before you can create a corporation, you first have to check if the corporate name is available. All right. So thanks to technology, we now have a system wherein we can check if the corporate name that you want has already been taken or is similar to an existing corporation's name. So we have technology to thank for that. No? So step one is a reservation of the corporate name. Number two, if the corporate name is available, you can draft and execute the articles of incorporation and bylaws. All right. So the articles of incorporation, this is executed by the incorporator or incorporators. Okay? So under the revised corporation code, pwede na ang one-person corporation. Alright? So there can be only one incorporator, there can be two, but there should be not more than 15. So 15 is the maximum and 1 is the minimum. Okay? So it's the minimum is 1, the maximum is 15. Under the old corporation code, the minimum is 5. Pero hindi na ganun, no? Kasi pinapayagan na ngayon ang one-person corporation. Alright? Basta it should not be more than 15. So it's 1 to 15. Next is number 3, filing with the SEC, the Articles of Incorporation, and the bylaws. In case the corporation is governed by a special law, such as an education institution or a banking institution, a favorable recommendation of the appropriate government agency is required. For example, you want to put up a corporation, you want to put up a banking corporation, anong agency ng government ang kailangan mo ng recommendation? If you want to put up a bank, you need a recommendation from the BSP. That's the Bangko Sentral ng Pilipinas. Okay. Number 4 is payment of filing and publication fees. And number 5 is the issuance by the SEC of the Certificate of Incorporation if all the papers filed after verification and examination are found in order. So class, let's talk about the Certificate of Incorporation. Paano mo malalaman kapag meron ka ng corporation? It's the issuance by the SEC of the Certificate of Incorporation. So this is a very important document. All right? The Certificate of Incorporation. Saan nagagaling yung Certificate of Incorporation? Nagagaling yung Certificate of Incorporation sa SEC. All right? It is the SEC that issues the Certificate of Incorporation. Okay? So ano naman yung Articles of Incorporation? Sino gumagawa nito? Ang Articles of Incorporation, ang gumagawa niyan, yung mga incorporators. Yung mga nagsisimula ng corporation. Alright? Sinasubmit yung Articles of Incorporation sa SEC. Now, the SEC will determine if all the requirements are complete. Tapos kapag complete yung requirements, magbibigay ang SEC ng Certificate of Incorporation. Alright? So who are the incorporators? Any person, partnership, association, or corporation, singly or jointly, but not more than 15. So class, under the revised corporation code, pwede nang maging incorporator ang partnership at saka isa pang corporation. Alright, so this is a very important change in the corporation code. Dati kasi, dapat natural persons lang ang pwede maging incorporators. But now, pwede ang juridical persons. Sino yung mga juridical persons? Yung partnerships and corporations. Okay? So, pwede na sila maging incorporator. Each incorporator of a stock corporation must own or be a subscriber to at least one share of stock. A corporation with a single stockholder is considered a one-person corporation. So this is also a very important feature under the revised corporation code. So pwede na ang one-person corporation. The corporate term, this is also a very important change. A corporation shall have perpetual existence unless its articles of incorporation provides otherwise. All right? Before kasi class, under the old corporation code, the maximum term is only 50 years. 50 ha, 50. 50 years yung dati na batas. Pero sa batas natin ngayon, all right? Ang sinasabi, a corporation shall have perpetual existence. But perpetual, how many years? Infinity, all right? So perpetual existence ang mga corporations ngayon. Okay? Pero pwede bang limitahan ng mga incorporators yung term ng corporation? Yes, pwede naman if gusto nila. If they want that the corporation shall last only for 20 years, 10 years, or 50 years, it is fine. It is okay. There's no problem there. Okay? But if wala naman sa Articles of Incorporation, let's say gagawa ng bagong corporation ngayon under the revised corporation code, pag wala kang nilagay na specific term, the presumption is it is perpetual. So panghabang buhay. No? A corporate term for a specific period may be extended or shortened by amending the Articles of Incorporation. Alright? So kung meron kang nilagay na term, kapag meron kang nilagay na term sa existence ng corporation, let's say gusto mo 50 years lang, tapos nagbago isip ng mga shareholders after 50 years, no? They can extend the life of the corporation by amending. Anong sabihin ng amending? Babaguhin, no? Babaguhin yung Articles of Incorporation. No? There's a process for that, no? We shall be discussing that later on. So, pwede bang paiksian naman? Yes, pwede. No, let's say, the class, no, let's say perpetual yung existence mo. Pero nafe-feel ng mga shareholders na hindi na kumikita yung corporation. So what will they do? Can they just stop operating all of a sudden? Masama yun, no? Kasi may mga penalties pag gano'n. Alright? Because a business is a going concern. Hindi porke nalulugi ka, pwede ka na basta tumigil. No? There's a process for that. Alright? Now, if you want to end the corporation's life, the shareholders, for example, naka perpetual existence, what they can do is amend the Articles of Incorporation. Sasabihin nila hanggang dito na lang. Okay? No extension may be made earlier than 3 years prior to the original or subsequent expiry date unless there are justifiable reasons for an earlier extension. So, sinasabi dito, kung gusto mo i-extend yung corporate life, let's say, mag-end na sa 50 years, no? Pwede kang mag-amend ng yung mga shareholders, pwede mag-amend ng Articles of Incorporation, pwede magpa-extend kapag, let's say, nasa 47 years na and above. No? Ang sabi kasi dito, hindi pwede na earlier than 3 years, magpapa-extend ka na. So, dapat maghintay ka ng 3 years before the expiration date. Alright? A corporation whose term has expired may apply for a revival of its corporate existence. So kapag nag-expire na yung term, mag-apply ka ng revival. Bubuhayin mo yung corporation. So this is also a very important feature in the revised corporation code. There is no minimum capital stock required. Okay? So actually under the revised corporation code, maraming mas dumali, no? mas dumali yung paggawa ng corporation. Alright? Stock corporations are no longer required to have a minimum capital stock, except as otherwise provided by special law. The 25% of 25% rule no longer applies under the revised corporation code. Hindi ko na i-discuss to kasi anyway, it is no longer applicable. Alright? So basta there is no minimum capital stock required. Alright? Now, this is under the Constitution, Filipino percentage ownership requirement regarding corporate capital pursuant to Article 12, Section 2 of the 1987 Philippine Constitution. So class, before we discuss this, it's very important to know the nature of our Constitution. Okay, our Constitution is the highest law of the land. Alright? So sabihin yung Congress, hindi pwedeng gumawa ng batas na labag sa ating Constitution. Alright? Ulitin ko, our Constitution is the highest law of the land. So kapag gagawa ng batas ang Congress, dapat isipin ng Congress, teka, itong ginagawa kong batas, hindi ba to labag sa Constitution? So yun, importante yun. So itong mga requirements ito, it is written in the Constitution. So it's very important. Number 1, corporations for exploration, development, and utilization of natural resources. At least 60% of the outstanding capital stock of which is owned by the citizens of the Philippines. Number 2, public service corporations. At least 60% of the outstanding capital stock is owned by citizens of the Philippines. Educational corporations, at least 60% of the outstanding capital stock is owned by citizens of the Philippines. So let's discuss the meaning of the Articles of Incorporation. It is the document prepared by the person or persons establishing a corporation. It is filed with the SEC. Corporation created by special law has no Articles of Incorporation. Rather, its management is governed by its charter. It is also known as a corporation with an original charter. A corporation without an original charter is one which is created under the SEC. So class, it's very important to know about this, no? So, meron dalawang klase ng corporation, no? Merong corporation with an original charter and merong corporation without an original charter. A corporation with an original charter, ito yung created by law, no? It is one created by Congress. Ano example niyan? Merong PAGCOR. What is PAGCOR? PAGCOR is the Philippine Amusement and Gaming Corporation. All right? So there is a law passed by Congress creating PAGCOR. All right? Ano naman yung corporation without an original charter? Example yan, hindi yung Ayala Corporation, Jollibee Foods Corporation. Alright? Yan yung mga hindi created by a special law passed by Congress. Yan yung mga dumaan sa SEC. Yung PAGCOR, hindi yan dumaan sa SEC because it is created by Congress. Yan yung corporation with an original charter. So yun corporation with an original charter, yung ginawa siya ng batas. Yung corporation, ginawa siya ng Congress. Yung corporation without an original charter, it is one na ginawa ng SEC. Kasi gagawa ka ng bagong negosyo, gusto mong gumawa ng bagong corporation, saan ka pupunta? Sa Congress o sa SEC? Sa SEC. Alright? You will hire a corporate lawyer to file articles of incorporation for you. Tapos bibigyan ka ng SEC ng certificate of incorporation if all your requirements are complete. Okay? Ano yung nilalaman ng articles of incorporation? So these are the contents of the articles of incorporation. Number 1, we have the name of the corporation. The name shall be followed by Inc., Corporation, or OPC for a one-person corporation. Number 2, the specific purpose or purposes for which the corporation is being formed. Again, class, we are talking about the Articles of Incorporation. So please, wag tayong malilito sa Articles of Incorporation and the Certificate of Incorporation. Those are two very different things. Okay? Ang gumagawa ng Articles of Incorporation, sino? Ang gumagawa, yung incorporators. Okay? Sino gumagawa ng Certificate of Incorporation? Yung SEC. Okay? So number 2, the specific purpose or purposes for which the corporation is being formed. Okay? Kung bakit ginagawa yung corporation, kung bakit siya tinatayo, no? Must be stated with sufficient clarity and not too indefinitely. No corporation can be formed with a purpose to carry on any business not contrary to law. If there is more than one purpose, there shall be a primary purpose and then a secondary purposes. A corporation cannot be created for the purpose of carrying out a profession like law firms, accounting firms, etc. Because the mga law firms, accounting firms, ano pwede sa kanila? Pang partnership. Alright? So class, let's discuss about the purposes, no? The purposes for which a corporation is created. Pwede daw ba na, let's say, businessman ka, business-minded ka, pwede ka bang gumawa ng corporation na pwede mo pasukin lahat ng business? Na lahat ng parang papasukin mo. Hindi pwedeng ganoon, no? Hindi pwede na lahat na marami kang purposes. Hindi pwede ang purpose mo is to carry on any kind of business. Hindi pwede 'yon. Let's say gagawa ka ng corporation, ng business mo ay punerarya. Ang purpose ng corporation mo is to put up funeral parlors, to embalm, whatever. Yan, ganun, no? What if gumawa ng corporation na ang purpose is to put up restaurants, and put up restaurants and to cook food, to serve food, blah blah blah, yun yung purpose ng ng corporation. Hindi mo pwedeng sabihin na ang purposes mo magluto tapos mag-operate ng punerarya. Those are two very different things. Okay? So kung mapapansin yung class, no? So ganyan, no? So gagawa ka ng maraming corporations for many different kinds of businesses. Ang ginagawa ng mga conglomerates, no? Ginagawa ng mga businessmen, they put up holding companies. Gumagawa sila ng corporation, no? Ang purpose ng corporation na yon is to hold shares of corporations that do businesses. Like Ayala Corporation class, ano bang purpose ng Ayala Corporation? Ayala Corporation is a holding company. Ano yung mga hawak ng Ayala Corporation? Hawak ng Ayala Corporation ng BPI. Ano ang purpose ng BPI? Banking, no? Okay? Hawak din ng Ayala Corporation ng ang Ayala Land. Ayala Land is a developer. Iwalay na corporation ng Ayala Land at saka BPI because they have two very different purposes. Ang Ayala Land nagde-develop ng mga subdivisions, binebenta. So itong Ayala Corporation, no? May hawak siya ng mga shares ng Ayala Land and BPI. So that's just one example, no? Isa pang example, SM. Ano ba ang SM? Ang SM ba yung mga mall, yung mga mall lang ba ang SM? Hindi. Maraming hawak ng SM class. SM also holds BDO. SM also holds SMPH. Yung corporation na na sa mga super malls, it's under SMPH. Yung banking ng SM, BDO, yung BDO, no? There's a corporation ng BDO. Tapos meron pa silang condominium, it's SMDC. No? Yung SMDC, ito yung corporation na nag-handle ng mga condominium business ng SM. Alright? So laging merong holding company. Pag holding company yung isang corporation, ang purpose niya is to hold shares of various companies. So yun ang ginagawa. But the thing is, hindi pwedeng gumawa ka ng isang corporation tapos lahat ng negosyo papasukan na yun ang nag-ooperate. Hindi pwedeng ganun. At most, pwede lang maging holding company. Hawakan mo yung shares ng mga company na yun. Alright? Number 3, the place where the principal office of the corporation is to be located, which must be within the Philippines. The term for which the corporation is to exist if the corporation has not elected perpetual existence. Because under the revised corporation code, corporations now can have perpetual existence. The 50-year limit has been removed. The number 5, the names, nationalities, and residence addresses of the incorporators. The residency requirement has been removed, and juridical persons, partnerships, and corporations can now be incorporators. Number 6, the number of directors, which shall not be more than 15, or the number of trustees, which may be more than 15. So class, kung mapansin nyo dito, merong directors, merong trustees. Ano ba talaga? Kapag stock corporation yan, ang tawag directors. Okay? Pag non-stock corporation, ang tawag trustees. Okay? Tapos kapag stock corporation, ang tawag shareholders. Pag non-stock corporation, ang tawag sa kanila members. Anong example ng non-stock corporation? Yung mga civic organizations such as Rotary Club. Ganyan. The names, nationalities, and residence addresses of persons who shall act as directors or trustees until the first regular directors or trustees are duly elected and qualified. In case it is a stock corporation, the amount of its authorized capital stock, number of shares into which it is divided, the par value of each share, names, nationalities, and residence addresses of the original subscribers, and the amount subscribed and paid. In case of no par value shares, a statement of the fact of existence of such no par value shares. In case it is a non-stock corporation, the amount of its capital, the names, nationalities, and residence addresses of the contributors, and the amount contributed by each. The principal office of the corporation, this is the specific address of the principal office, which shall include the street number, the street name, the barangay, city, or municipality. So it has to be specific, no? Kasi para alam kung saan papadala ng mga summons, the court, etc. It's the place where corporate books are ordinarily kept and its officers meet. It is not necessarily the place where the business of the corporation is transacted. Alright? So basta kung nasa yung admin office. So parang gano'n. Kahit yung sales office nangyayari sa ibang lugar, okay lang yun. What if there's a change of address? If the new address is within the same city or municipality, there is no need to amend the Articles of Incorporation. What is required is the submission of an amended General Information Sheet or GIS to the SEC within 15 days from transfer. If a new address is in a different city or municipality, there is a need to amend the Articles of Incorporation. There's a process for that. We shall be discussing that later. So, perpetual corporate term. A corporation shall have perpetual existence unless its Articles of Incorporation provides otherwise. So again, the presumption is a corporation shall have perpetual existence. Panghabang buhay. Corporations with the certificates of incorporation issued prior to the effectivity of the revised corporation code and which continue to exist shall have perpetual existence. Existing corporations need not do anything if they want to have perpetual term. Sabihin yung mga dati ng corporation na may term limit, thus upon the effectivity of the revised corporation code, the presumption is perpetual sila. Alright? Upon the effectivity of the revised corporation code. Naging perpetual na lahat. No? So, talk about amendment of the Articles of Incorporation. It includes extension or shortening of corporate term. No extension may be made earlier than 3 years prior to the original or subsequent expiry dates unless it is justified. So hindi pwede na masyadong maaga ka mag-extend, no? So you have to wait 3 years prior to the original or subsequent expiry date. Number two, increase or decrease of authorized capital stock. So you already know authorized capital stock from Title 1. Number three, amendments to purposes of the corporation. Kasi magbabago ng business yung corporation, ganyan. So papalitan yung purpose. You have to amend the Articles of Incorporation. So what is required here? And this is very important class, no? So number one, majority vote of the members of the board of directors in the case of stock corporations or trustees in the case of non-stock corporations. So una muna, majority vote of the members of the board of directors. So majority vote. Okay, majority vote of the members of the board of directors. Number two, at least 2/3 vote or written assent of the shareholders representing at least 2/3 of the outstanding capital stock or 2/3 vote of the members in the case of non-stock corporations. So klase 2/3 na to, no? It talks about the outstanding capital stock. Ano sabihin nun? Paano kung yung isang shareholder, he or she owns like 70%? No? What is 2/3 class, no, in percentage? What is 2/3? 2/3 is 67%, right? So what if one shareholder already owns 70% of the outstanding capital stock? Ano sabihin nun? Ang sabihin nun, kahit boto lang niya mag-isa, edi ano, that's more than 2/3 2/3 of the outstanding capital stock already. So pwede siya yung mag-decide, no, kung i-amend yung Articles of Incorporation kahit siya lang. Alright? Kasi siya yung may-ari ng 2/3 of the outstanding capital stock. Alright? So yung vote pa lang niya, that's more than 2/3. Okay? Acquisition of juridical personality. Upon the issuance of the Certificate of Incorporation to the incorporators by the SEC. So again, this is a very important document, the Certificate of Incorporation. So kapag na-issuehan na yung corporation ng Certificate of Incorporation, there is already juridical personality. Again, class, now remember the definition of a corporation. It is an artificial being created by law. It is not created by mere consent. No? Hindi siya parang partnership. Ibahin ninyo ang corporation sa partnership. A partnership is created by mere consent of the partners. A corporation is created by law. Okay? So what is a de jure corporation? It is a corporation created in strict or substantial conformity with the mandatory statutory requirements for incorporation and whose right to exist cannot be successfully questioned by any party, even in a direct proceeding by the state. Ito class yung walang kaduda-duda, kompleto sa requirements. Yan ang de jure corporation. Okay? What is a de facto corporation? One which actually exists for all practices as a corporation but has not complied with all the requirements necessary to be a de jure corporation. It has complied sufficiently to be accorded corporate status as against third parties but not against the state. So ito may pangilan-ilan na kulang or hindi kompleto. So yan ang de facto corporation. Paano kapag walang certificate of incorporation? Is it a de facto corporation? The answer is no. Alright? There is no corporation at all. So sobrang importante yung certificate of incorporation. So requisites of a de facto corporation, a valid law under which a corporation might be incorporated, a bona fide attempt to organize a corporation under such law, and actual use or exercise in good faith of corporate powers. There is no corporation in the following cases, not even a de facto corporation: absence of articles of incorporation, failure to file articles of incorporation with the SEC, and lack of certificate of incorporation from the SEC. Kung wala yung mga bagay na to, there is no corporation at all. Kahit de facto corporation, wala. So how do you question the validity of a corporate existence? It's only through a direct attack by the state. Only the state is the proper party to question the validity of a corporate existence. A collateral attack is not allowed. Ano sabihin na? Ano sabihin ng collateral attack? No? So a collateral attack on the valid existence of a corporation is an incidental attack on the validity of existence of a corporation in a case which has a different lis mota. I'll give you an example, class. Right? Kasi I encounter this from time to time. No? Na magkukonsulta sa akin. No? Sabihin nila, ay attorney, may umuupa ako sa corporation na to. Ganyan, no? Pero parang hindi naman siya tunay na corporation. So, kumbaga, sinisingil kasi sinisingil siya. Alright? Hindi siya nagbabayad. So, pinapaalis siya. No? Pinapaalis siya nung corporation. Ganyan. Gusto niya questionin yung existence ng corporation. Pwede ba yun? The answer is no. Alright? Alright? Only the state can attack the existence of a corporation. Alright? So, ibig sabihin kasi kinakasuhan siya ng let's say ejectment kasi pinapaalis na siya. Hindi na pwede sabihin sa kaso niya, teka, hindi naman tunay na corporation. Hindi pwedeng ganoon. Alright? So, for example, nagpautang ka. Gusto mong kasuhan yung corporation na nangutang sa'yo. Alright? Tapos hindi siya nagbabayad. Tapos hindi mo pwedeng i-atake yung existence ng corporation niya. Alright? So yung class ng collateral attack, ibig sabihin, merong hiwalay na kaso. No? Tapos gusto mong atakihin yung existence ng corporation. So that becomes a collateral attack. Hindi pwede a collateral attack in questioning the validity of a corporate existence. It's only a direct attack by the state. That's the only thing that's allowed to question in questioning the validity of corporate existence. Tapos sino yung proper party? O sino yung proper party na gumawa ng direct attack against the existence of a corporation? It's only the Solicitor General. The Office of the Solicitor General. Ito yung parang lawyer ng government. Okay? It is the Solicitor General. Like co-warrant to proceedings. Now let's talk about a corporation by estoppel. It is an ostensible corporation. Ostensible? What is that? Ostensible, parang nagkukunwari na corporation. An ostensible corporation comprising of persons who assume to act as a corporation knowing it to be without authority. Such persons shall be liable as general partners for all debts, liabilities, and damages to third persons who believed in such persons. All right. So again, we're encountering estoppel. We already discussed partnership by estoppel before. Ito naman, we are presented with a corporation by estoppel. So parang corporation by estoppel, nagkukunwari kayo magkakaibigan na may corporation kayo. So nakipag-business kayo sa isang stranger na naniwala na corporation na kayo. Pwede kayong kasuhan. Pwede kayong kasuhan. It's as if na may corporation kayo. So pwede na habulin lahat ng mga sumama dun sa pagkukunwari. Alright? Siyempre, hindi na pwede kasuhan yung, let's say, for example, ako, sinabi ko na kasama ko sa corporation si Barack Obama. Kunwari lang. No? Yung mga tao na naniwala sa akin, pwede ba nila habulin si Barack Obama? Hindi. Alright? Kasi wala naman kinalaman si Barack Obama nun. What if sinabi ko, for example, katabi ko isang member ng BTS, kunwari, o katabi ko. Sabi ko, kasama ko sila sa corporation. Tapos sinabi nila, yes, we are part of your corporation, blah, blah, blah. Can you sue them? Well, yes. No? Because their actions led you to believe that we are in the same alleged corporation. Such persons shall not be allowed to use the defense of lack of corporate personality. In the same manner, anyone who assumes an obligation to an ostensible corporation cannot resist performance on the ground that there is no corporation. Alright? So yung mga nagkukunwari na may corporation sila, hindi nila pwede sabihin, teka, bakit mo kami kinakasuhan? Wala talaga kaming corporation. Hindi pwede because they're in bad faith. No? They led people to believe that they have a corporation. So mananagot sila doon. So effects of non-use of corporate charter and continuous inoperation. A certificate of incorporation shall be revoked if a corporation does not formally organize to commence its business within 5 years from the date of its incorporation. So remember the time period class, no? 5 years. So sabihin, dapat within 5 years bago ka ma-issuehan ng certificate, 5 years after mo ma-issuehan ng certificate of incorporation, dapat nag-start na yung business. No? Siguro naman, it's enough time for you to commence your business operations. Under the old corporation code, it's 2 years. Ngayon pinahaba siya, no? Under the revised corporation code, it's now 5 years. So kapag 5 years na, tapos hindi ka pa rin nagsisimula ng business mo, i-revoke yung certificate of incorporation ng corporation mo. So you have to start, no? Mag-register ka ba sa BIR, kukuha ka ng mga business permit, then magko-commence ka ng business operations. What is the reason for rule against collateral attack? No individual right is invaded. It would produce endless confusion and hardship and probably destroy the corporation if the legality of its existence could be questioned in every suit to which it is a party and for public interest. So yun kasi no individual rights invaded actually. And also kapag pwede mong questionin yung validity ng corporation, masyado magulo yan, no? Alright, so it should only be a direct attack by the state through the Solicitor General. Let's go back to effects of non-use of corporate charter and continuous inoperation. If a corporation has commenced its business but becomes inoperative for a period of at least 5 consecutive years, the corporation will be placed under delinquent status after due notice and hearing. So kapag bigla ka tumigil ng 5 years, ilalagay ka sa delinquent status. Alright? Delinquent operation shall have a period of 2 years to resume operations and comply with all requirements. Kapag gusto mong bumalik sa active status, you have a period of 2 years to resume operations and comply with all of the requirements. So again, class, kung gagawa ka ng corporation, make sure you're committed to it. Panindigan mo. Okay? Unless sobrang nalugi ka or you're transferring to a different place, saraduhan mo or ibenta mo. Pwede. You can do that. You can sell your shares to different people. Okay, class, let's end here. Take care and God bless.